chilly in here. I feel like my nose is sniffling. Anna, you know what I did on that MTRP previously? That I didn't do it. I'm so sorry.
It's okay. We made a note. We were in this.
Okay, I'm doing it on this one.
Thank you.
All right, so are you Quindarius Moore?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Moore, in cause number 23, DCCR 1237, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation December 5th of 2023 for the state jail felony offense of unauthorized use of a vehicle, and that was a 5-year deferred probation. Is that correct? Looks like y'all have elected to go on just 1, 2, and 3.
That's right, Judge. The state would abandon the remaining counts, allegations.
Looks like July 24th was quite the day over in Louisiana, wasn't it? It wasn't, was it? Good grief. All right, so the state's elected to proceed on counts 1 through 3. Count 1 alleges you violated your probation by committing the offense of simple burglary, July 24th, 2024 in Calcasieu Parish, Louisiana. And is that true or not true?
True.
Count 2 alleges that you committed the offense of simple burglary, felony on July 24th of 2024 in Calcasieu Parish, Louisiana. No, well, this one just says, yeah, Calcasieu Parish, Louisiana also. It looks like these are different. This is, must be different units of the same
Different
place.
victims, Your Honor.
They're all, it's like 700 Henning Drive, number 65, number 67, and number 68. So they must have been different units of the same place. So count 2 is to unit number 67. And is that true or not true?
It's true.
Count 3 alleges that you committed the offense of simple burglary July 24th, 2024, and that one is to 68. Is that true or not true? Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Moore is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to find you guilty of unauthorized use of a vehicle and find you guilty of that offense. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. Good luck to you, sir. You can go back with the bailiff. Good morning.
Good morning.
You're Emilio Rodriguez?
Yeah.
And I'm going to take judicial notice of the court's file in Mr. Rodriguez's case. And Mr. Rodriguez was examined for competency to stand trial by Dr. Crapon. Received that report, which is dated February 12th of 2025. And in that report, the finding is that Mr. Rodriguez is currently competent to stand trial. Is there any other evidence with regard to competency?
Not from the state.
All right, then I am going to find at this time, based on that report, that Mr. Rodriguez is competent to stand trial. This is an MTRP, so what's the announcement, Mr.
Yes, Judge,
Mitchell?
but we're going to plead true.
Okay, is there any agreement?
No, Judge,
Okay,
the agreement's just to come to you and
Sure.
make arguments, so.
okay, let me get that pulled up then. Mr. Rodriguez, the best you can, would you raise your right hand for me? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And Mr. Mitchell, will your client waive the formal reading of the motion?
Yes, Judge.
Mr. Mitchell, I have a motion to revoke your unadjudicated probation.
Mr. Rodriguez. Judge.
I'm sorry, Mr. Rodriguez. No, I do not have a motion to revoke yours. Not that you're on one, just a joke. Mr. Rodriguez, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation back on April 15th of 2024 for assault of a public servant, and that was a 5-year deferred probation. Is that correct? This motion says that you violated your probation. Count 1 alleges that you committed the offense of an offensive touch on June 24th of 2024. And is that true or not true?
Sure.
Count 2 alleges that you failed to conduct yourself in a courteous and professional manner with the probation court officers and staff, probation officers. And is that true or not true?
I don't understand.
So it's saying that you did not conduct yourself properly when you were at probation by inappropriately touching Ms. Willis and who was with the Bella Mente Counseling. And is that true or not true?
Yes,
Okay, that's true.
sure.
All right, so did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
I do.
And did you plead true to those counts because you actually did what they said you did?
It's true.
All right. I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case. I'm going to ask probation to do an update, see how things are going, what possibly can be done, or what's going on in the jail at this point, and then we'll come back later for sentencing. If there's anything that's important, Mr. Rodriguez, make sure you visit with Mr. Mitchell about that. He'll let me know and present your information to me on your behalf when we come back. All right, thank you. You can go back with the bailiff.
Thanks.
Now be dismissed, Your Honor?
He needs to be printed.
Okay. Good morning, Your Honor.
Good morning.
Good morning, sir.
Good morning. Are you Dylan Blackwell? And Mr. Blackwell previously was here, entered a plea of guilty to sexual assault of a child. The agreement was for a cap of 15 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Are there any additions or corrections?
No, Your Honor.
All right, Mr. Vasquez, you may proceed.
Well, Judge, you already know what I'm gonna plead for. Salam was 21 when this occurred, when the girl was not yet 17. She was 6 or 7 months shy of 17. It was very stupid and irresponsible and hormonally insane. I don't know if he's been living underneath a rock or what for the last 5 years, but he should know someone that age cannot consent.
Let me ask Mr. Hoffpower, or what I have read in the pre-sentence report, and there's no statements of interested parties, and so the victim or her family, no one responded to this. what I'm reading is that the girl I guess here's my question. I don't see any allegations that this was not consensual. Now, I obviously understand that legally she cannot consent. So I'm not talking about legally, I'm talking about factually consensual. It appears to me as though it was factually a consensual partying. They actually reached out, the girls, to Mr. Blackwell, if I'm correct. Go see alcohol, want to party, and all the things happened consensually, factually. Am I correct on that?
That's the understanding. Now, if we go by just the defendant's account, which is in the
But-
PSI,
We don't have another account. And so if we don't have another account, then I guess my question is, why are we even talking about, and let me tell you something, Mr. Blackwell, what you did was absolutely stupid. But when we've got a 21-year-old and a 16-year-old, when the 16-year-old's the one that reached out to go party and do these things, do I feel like there needs to be some punishment, some rehabilitation, some better judgment calls? 1000%. Do I feel like I'm gonna send this young man to prison for that? I mean, Mr. Hoffpower, I mean, is that what you're asking?
Your Honor, we just, with the cap, and all we have, I can't speak to why they did not respond to probation. We were ready for trial. If you remember this case, we brought this to, we were ready to go to trial.
Right.
And so when we notified them about when the sentencing was. Now, the account by the defendant is, there's still no attrition in regards to whether or not that they can't consent, even when he knows she can't consent, he acts like it was, what the court's acting like it was. He picked up someone and didn't check whether how old she was. And it seems to me that he's not acting like he did something wrong. It's just, I just picked up a girl off of Instagram and brought him out to party. And I don't see where there's any, acknowledgement of guilt in this, and I believe we're here, he pled guilty.
Well, he pled guilty and could go to prison for 15 years, so that's some acknowledgement, I would think.
Now,
I mean,
also included in this, Judge, is the court has received.
I have that, and I'm
is
gonna
that-
get to that in just a minute.
that As to the other, I can't speak to, we've given them notice to when the hearing is, and they've been called by probation.
Okay.
And that was the plea, was the cap to avoid a trial. So that's what happened. And the court, the state is just leaving it for the court to make that decision. We're not arguing forcefully for prison time, we're just leaving that at the discretion of the court.
I mean, no matter what, Mr. Blackwell now is gonna have to register as a sex offender, gonna have to go through treatment, all that stuff is gonna be out there. And I don't want anyone to think that what I'm saying is that, Mr. Blackwell, that I think what you did was okay in any way, because it's not. I just don't think this is the case and this is the set of facts, unless there's something else that I'm missing for some lengthy prison sentence, when, we're not talking about a 12 or a 13-year-old. We're talking about someone that was almost legally able to consent, reaching out. And
I think the court needs to know there is one other factor that adds to this, that videos of this act were posted online. So a 16-year-old in sexual acts were posted
Right.
online in this case.
but who did that? That
That is
wasn't-
something that was to be proven whether or not,
Who posted
It was
what?
posted.
And yeah,
but
that's.
it was posted.
I mean, it was a ridiculous situation. It was. I mean, I guess, Mr. Blackwell, tell me how you feel about this.
My defense, I did make some irrational behavior. I should have been more level-headed about the situation.
mean, you understand that no matter how willing someone is, you are the older person and have to make better decisions. So tell me what's been going on in jail. Looks like we have last year, looks like pretty much every single month, just about, you had some type of write-up. April, May, June, August. August was a bad month. September, November.
Most of my cases, I was talking after the time, or when it was time for me to get up, I ended up oversleeping, so I received verdicts for that.
But if you, you're right, but I mean, if you can't follow rules while you're in custody, that doesn't give me a lot of good feelings about whether you can follow rules if I give you a probation. Does that make sense to you? That you're coming in front of me. Of course, since you've pled, you haven't been in trouble, so that's a good thing. Knowing that you're gonna come in front of me and possibly go to prison for 15 years. I mean, I think I've explained my position and why I have this position. And again, I don't want you to think that I think what you did was okay, because it wasn't. But because of the situation and because of the ages of everyone, and because that there is absolutely no evidence that this was factually not consensual, what I'm going to do today, Mr. Blackwell, is I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. But today I'm going to defer all proceedings and place you on probation for a period of 10 years. You are going to pay a $1,000 fine. You're going to follow all of the rules and conditions of probation, which means being on the sex offender caseload. You will have to register as a sex offender. And you will have to, you're not going to be allowed to have social media, at least for some amount of time until I say so. I am also going to order that as a condition of your probation, you enter and successfully complete the cognitive track of the ISF program. That means you're not getting out of jail today, right? You're going to a program that is designed to teach, especially younger people, better ways of thinking and decision making. And I'm hoping that when you do that, you'll get out and you will make obviously better decisions, be successful on this probation, because the opportunity that you're being given today is huge. You actually do not have a felony conviction on your record, and I'm not doing that for you. I want that clear to everyone. The reason I'm giving you a deferred probation is because if you violate that cap of 15, it's off the table. So if you violate your probation, I can sentence you anywhere between 2 years in prison all the way up to 20 years in prison. So this is your chance. I don't want you coming back in here later and saying, well, I need help with this, or I tested positive and now I need help. You need to ask for help ahead of time if you need help with anything. If you're drinking too much, if you're smoking marijuana, I don't know whatever it is. If you need help getting a job, if you need help with where to live, you better ask those things and not get in trouble and then come back and ask me for a chance again, because this is the chance I'm giving you. Do you understand? I do need y'all to do, before you leave, I'm going to hand you a trial court certification that shows this was an agreement I followed, and so you've waived your right to appeal. Y'all did not fill out the sex offender registration paperwork. You're going to need to go over some paperwork before you leave the courtroom today and sign it. Mr. Vasquez will go over that with you. It explains the process of sex offender registration requirements. It's very important that you do that correctly for two reasons. One, it's part of your probation that you have to register as a sex offender. Two, it's the law that you have to register. And if you don't, not only will your probation potentially be revoked, you'll also have another felony offense. It's that serious. So that's to protect the community so that I feel better about what I've done today and that everybody knows that you're doing what you're supposed to be doing. Do you understand? All right, here's that certification. If y'all will get that other done before he leaves the courtroom, please.
Thank you, Judge.
All right,
Thank you.
thank you. Good morning, ma'am. Are you Jamie Story? And Ms. Story, you were previously in court, entered a plea of guilty to theft of property with previous convictions. That's a third-degree felony because of some prior offenses. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Are there any additions or corrections?
No correction, maybe clarification, Judge. I noticed on the substance abuse history, as far as methamphetamine and heroin goes, it looks like it reads that she uses once a month on the meth and daily on heroin. She tells me she's been clean since 2017, since she went to that outpatient center, so that at the time when she was using that, that's how much she was using, but.
It says the date of the last use
Okay.
was 2017. Yeah, okay. Anything else?
That's all I have.
All right then, Ms. Story, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property, sentence with previous convictions, sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections, but suspend that, place you on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, this, especially with your history, is a great opportunity because you will be able to serve that 10-year sentence that you agreed to while you're out on probation. The other side of that, though, is if you violate any condition of probation, you're going to be brought back in court, your probation will be revoked, and you will be looking at that 10-year sentence that you've already agreed to. Do you understand? All right.
Sorry to interrupt, just so Ms. Story is aware, because I know the court probably looked at the PSI and wondered why I made this offer. I'm sure you will remind me if she's back.
Yes.
She shouldn't have gotten probation. We made a TDC offer in the alternative today. Maybe the court might want to reject, but we will be asking for the upper end if she's back in the TRP.
So Ms. Malfino's right, and she made that alternative offer today, and because they know how I feel about these cases. You continue doing the same thing over and over again. At some point, you're going to prison for a very long time, and this is going to be that time because you just agreed to a 10-year sentence in prison. So you either get your life together or you go to prison for 10 years. It's not negotiable. Every now and then there's negotiations that take place on those, but really I don't have to allow any negotiations on a motion to revoke probation where you've already agreed to your sentence ahead of time. So you get it together or you don't. All right? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Rojas. And Ms. Story, I'll also tell you, probation is there to help you. And so if you have any issues, if you have any feelings that you're going to relapse, if you have anything like that, you need to go to probation on your own when that's happening and say, hey, you're grown, you're old enough to know now what's going on, and that if you're having those issues and if you're having problems and you feel like stealing or you feel like using or whatever it is, you need to go to them for help, because if you don't and you violate, coming back in here is not going to help anything. Okay, you can go back with the bailiff. Good luck to you, ma'am. Federico Ortiz, Mr. Rojas. Good morning, sir. You Federico Ortiz?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Here we go, Your Honor.
Mr. Ortiz, in cause number 24 DCCR 2334, you're charged with a second-degree felony offense of burglary of a habitation, and that's from October 14th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you reached is for a 5-year deferred probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Do you understand? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Ortiz is not competent?
No, Your Honor.
Does Mr. Ortiz have any other holds for any reason? Do you have any other cases pending or any holds?
No.
I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back at a later date for sentencing. Mr. Smith, what's the state's position with regard to bond reduction based on the nature of this plea agreement?
I don't think we're opposed to it, just as Luke's case, but.
Any, yes. All right, so here's what I'm going to do. At this point, it looks like there's something called some kind of ID hold at the jail for being uncooperative. I don't know what that means, but if that comes back that that is cleared or that was whatever, I'm going to find out what that means. If I'm satisfied that that's something that I'm comfortable reducing a bond, then I will do that later today. If not, the bond's going to remain the same while I figure out what that is. All right, you can go back with the bailiff. Thank you.